Hello everybody. So this talk is going to be about the British Constitution and the legal system. Well, famously, Bagehot wrote a book called The English Constitution, but he ought to have called it the British Constitution. Or there's Professor Vernon Bogdanor, who was Professor of Politics at Oxford University for many moons. And he said when he was at school there was a subject called the British Constitution, but he chose not to study it since it doesn't exist. There is no British Constitution. Well, the United Kingdom's got an uncodified constitution. Some people prefer to say unwritten. So what is a constitution? Well, it's the laws concerning governance, saying what the national territory is, whether the head of state is a monarch or a president, how someone becomes the head of state, what the state religion is, if any, and whether there is some sort of federal system, what legislatures exist, what the parameters of their powers are, what role the courts have, what powers are accorded to the executive, and so forth, governing the interplay of the different branches of government. Might be some of the key legal principles might be enshrined in the Constitution likewise. So the Constitutional Reform Act was passed in 2005, and it says this act does not adversely affect A, the existing constitutional principle of the rule of law, or B, the Lord Chancellor's existing constitutional role in relation to that principle. Close quotation. So the Lord Chancellor is an office which goes back many centuries, long before there was a Prime Minister. Note that the Lord Chancellor is not the Chancellor of the Exchequer. The Chancellor of the Exchequer is called the Finance Minister in most countries. There's also Chancellor of the Duchy of Lancaster, Chancellor of the Duchy of Cornwall, and that's not, neither of those are the Lord Chancellor. Okay, so the separation of powers is there. Montesquieu, that French philosopher in the 17th century, he opined that we couldn't have liberty unless there's separation of powers. He wrote that in Spirit of the Laws. Anyway, so the Constitutional Reform Act was really seminal, and it established the United Kingdom Supreme Court. Prior to that, in the House of Lords, law lords, as in judges, they'd heard cases. So when you say the House of Lords sat in a case, it doesn't mean the hereditary peers, the life peers, or the Lords Spiritual. It only meant the judges, usually 12 of them, in the House of Lords in the old days. But from 2009, the House of Lords no longer had any judges in it. And it's true that the judges in the Supreme Court, they have the title Lord or Lady, but they have no right to sit in the House of Lords. Anyway, so the Supreme Court was set up partly because they felt that the system prior to that time was in breach of the principle of separation of powers, because those judges were both legislators and they had a judicial role. Okay, so parliamentary sovereignty is core to the British Constitution. Pursuant to the passage of the Human Rights Act in 1998, it was felt that this was incompatible with the separation of powers, the way there were judges in the upper chamber of Parliament. So other countries have a far more orderly constitution. The United States Constitution is very easy to find. It's not even that long. India's got its constitution, which was perfected by Dr. Bamji Ambedkar in 1950. Germany's got its Grundgesetz, or basic law. That's their constitution. And they've got a very, very short article, and it says the death penalty is abolished. And that was in German is only 4 words, because death penalty is 1 word. South Africa's got a written constitution. Most countries have them. Republic of Ireland, we've had one since 1937. So the Human Rights Act is not a written constitution, but it is a set of rules about certain liberties and rights which are guaranteed to people. So some statutes are held to be constitutional statutes. Remember, a statute is a law passed by a legislature. So your statutory rights are your rights which arise from a statute. So people say that the UK has had a written constitution. It evolved down the centuries. There are also conventions, but a convention, is it just that, a convention and not a law, or does it have force of law? And that's a point of some contention. Anyway, so the UK constitution is mostly uncodified, as I said. So most countries have got written constitutions. However, New Zealand and Israel do not. So other countries, like Roman law countries, generally got administrative law, as in to set up how the law actually functions. Makes it a lot easier, whereas it's all quite unclear in the United Kingdom. Now, one of the points that's made in favour of the UK's constitution is it's more adaptable and can bend when it is needed. The other hand, people say it scarcely exists and people's rights are not properly protected. People can act ultra-vires and get away with it sometimes. It's difficult to know what the constitution is. Works of authority are said to be part of it. Erskine May, this book about parliamentary procedure, the English Constitution by Bagehot. But whoever said that's part of the Constitution? Parliament never voted that's part of the Constitution. I mean, I think the UK could pass a Constitution Act saying that book by Bagehot is part of the Constitution or not, or that it has no constitutional effect. Because what authority is there to say this is part of the Constitution? Bagehot was never elected to Parliament. He was a banker. Right, and he just simply wrote that book. I could write a book. Should that be part of the Constitution? If not, why not? If it was accepted by enough people over time, would it be part of the Constitution? And how many people would have to accept it? How would we know? As I say, it's all just so very unclear and amateurish. So in the United Kingdom, you can't access a single document saying this is part of the Constitution. So these works of authority are held to be part of, like Bagehot and Erskine May. So the core constitutional principles are 1, parliamentary sovereignty, 2, the separation of powers, and 3, the rule of law. So coming on to parliamentary sovereignty, this is a central pillar of the constitution, so that courts cannot strike down legislation, Parliament can pass any laws, or put it this way, this is what Bagehot say, no Parliament can bind its successors. If Parliament to pass a law saying Parliament can never outlaw smoking, if next year Parliament says we want to outlaw smoking, well, they would be allowed to do that. So despite Parliament previously having said it can never be outlawed, Parliament can change its mind and outlaw it. Or, for example, the Act of Union, passed in 1800, uniting Ireland and Great Britain into a single realm, and that was forever. The word forever was used in it. Nonetheless, the Government of Ireland Act, 1921, the major portion of Ireland, we left the United Kingdom. So Parliament can change its mind. Parliament elected this year cannot prevent Parliaments elected subsequently from doing anything. Or the other one that Bagehot said is Parliament is omnipotent in all things except the power to destroy its own omnipotence. Close quotation. So Parliament cannot legislate itself out of existence. There's no legal power to destroy its own independence. A bit like what Arthur Griffith said about the Irish Parliament prior to 1800. So people say, well, what about the European Union? Because the UK had to take orders from an external authority. Well, that's true, but Parliament retained the right to end that situation, and indeed did end it. That's called Brexit. Okay, so there's no official difference between ordinary and constitutional law. Statutes are all passed in a like manner. So this is the negative limb of parliamentary sovereignty. So acts of parliament, they cannot be invalidated by courts, and legislation can't be ruled to be a nullity if it's repugnant to the constitution. Whereas in the Republic of Ireland, our Supreme Court can do that. The legality of it can be tested. So the traditional view of parliamentary sovereignty was expounded by Albert Venn Dicey in 1885. He was Professor of Public Law in the University of Oxford. He wrote an introduction to the study of the law of the Constitution. Now, not everybody likes Dicey. He was an arch Tory. He was against Home Rule for Ireland. Some people said he was racialist. He died in 1922, so perhaps not so relevant anymore. So over time, these legal developments have led to this notion of parliamentary sovereignty emerging. So, but the constitutional statutes are classified as such by courts, but as I say, that doesn't mean they're passed in a different way. There's Thoburn against Sunderland County Council 2002. He's the metric master, the bloke who was selling in pounds and ounces rather than kilos and grams as required by European Union legislation. So Lord Justice Law sat in this case, and he said, we should recognise a hierarchy of acts of parliament, as it were, ordinary statutes and constitutional statutes, close quotation. So, and other courts have agreed with that. There's our High Speed 2 Action Alliance Limited against Secretary of State for Transport 2014, where the court agreed that the constitutional statutes are different. So the UK acceded to the European Economic Community in 1973. In 1993, the European Economic Community changed its name and its nature to be the European Union. So EU law, it takes precedence over UK law where the two clash. So the British Parliament was subordinate to EU, the European Parliament. Some people said that was an affront to parliamentary sovereignty. But anyway, so we know that Parliament can pass any laws. If there's a clash between a statute and common law, statute shall prevail. Anyway, what else should I point out? Well, I think we'll come on to the separation of powers a bit later. Toodaloo.